Hello, and welcome to Brief Encounters and to Making a Difference, Inspirational Women Leaders in Environmental and Energy Law and Policy, a podcast sponsored by the DC Bar and the Women's Bar Association of DC. I'm Kathy Pagano of the board of the Women's Bar Association of DC.
I'm Kathryn Caballero with the DC Bar Steering Committee for the Energy, Environmental, and Natural Resources Community and co-chair of the Women's Bar Association Energy and Environmental Law Forum.
Today, we're very pleased to have as our guest Bridget Bailey Lipscomb, the Assistant Director of the Environmental Torts section of the Civil Division at the U.S. Department of Justice. After earning degrees from Grambling State in History and Public Administration and her law degree from the University of Tennessee, Bridget worked as a partner at Lewis King in Knoxville, Tennessee, as legislative counsel for Senator Lamar Alexander, and as a senior trial counsel in the Department of Justice's Civil Division. We'll hear about Bridget's expertise in environmental contamination exposure cases, and also about her role as president of the Women's Bar Association of DC, all of which focus on her passion, helping others succeed. Today, we'll also be asking Bridget for tips to help with your career path. And just so you know, all participants are here today in their personal capacity and do not represent the views of the federal government. Welcome, Bridget.
Thank you so much, Kathy and Kathryn, for having me. I am delighted to be here.
Thank you, Bridget. We're very excited to discuss your work in defending the United States in environmental torts matters brought under the Federal Tort Claims Act and environmental statutes. Could you give us an example of a bread and butter case, as well as some of the more precedential or complex matters that you have worked on?
Yes, Kathryn, if it's okay, I'll give two preliminary matters. First, in addition to what Cathy said, that these are my personal opinions, I want to say that everything I say today regarding environmental tort cases are public record. So I will not discuss private ongoing strategies. I just want to make that clear. And let me give you a little background on the Federal Tort Claims Act before I go into the bread and butter cases. I practice under the Federal Tort Claims Act, which is a limited waiver of sovereign immunity. This statute allows individuals to sue the United States, federal agencies, and federal employees for personal injuries and property damage based on negligence. But only the United States can be a defendant in these cases. So if you have a case against an agency or an employee, you must sue the United States. Congress has set certain requirements that must be met before a Federal Tort Claims Act case can go forward. And Congress allowed certain exceptions to the Federal Tort Claims Act, which means that even if an individual meets all of the preliminary requirements, the suit may not go forward if it is barred by an exception. So I just wanted to lay that out to explain what I do every day. There are 4 offices in the Department of Justice that practice primarily under the Federal Tort Claims Act. They're all in the Civil Division. My office is one, Environmental Torts. There's a Federal Tort Claims Act office, a Constitutional Torts office, and an Aviation, Space, and Admiralty office. Our offices all exist to protect the public fisc, or taxpayer money. So while Congress gave individuals the right to sue the United States, it created offices to defend the cases so taxpayer money is only paid out when legally justified. That's always our hope. My bread and butter cases. Okay. So in environmental torts, our cases basically stem from exposure to contaminants. And most of those cases emanate from, say, World War II activity. What I mean is, in 1945, there were no environmental statutes that prohibited burying munitions, for example. In fact, at that time, it was commonly understood that the way to properly dispose of contaminants was to bury them. We later learned that these past disposals contaminated soil and water. So our basic case stems from burying munitions or underground storage tanks that were placed under the ground back in World War II. And fast forward, a plaintiff says that he or she has been injured or has had cancer or has had a lot of health problems because the drinking water that is near a World War II site was contaminated and caused him or her injuries, or it reduced the value of her property. So that's our bread and butter case.
So Bridget, why don't you give us an example of a case that is more complex, that your office, which is in this very interesting area of the law, has to spend additional resources on a complex matter that might not be related to, for example, the World War II contamination?
We get a lot of mold cases, believe it or not. So we deal with a lot of cases where people allege that they were exposed to mold and they have a lot of injuries. And a federal agency was negligent in the way it should have, say, removed some water from a building or something like that. So we get a lot of those cases. Another case that was somewhat complex that we handled a few years ago was a hantavirus case in the Yosemite National Park. So what that case stemmed from was double-sided tent cabins. So in Yosemite National Park, some residents went, or guests, I should say, went and they stayed at Yosemite National Park and they paid to rent double-sided tent cabins. They were canvas cabins, and there was like a canvas wall on the inside of the cabin and a canvas wall on the outside of the cabin, and there was space in between. They were built that way for warmth. So these cabins were utilized in the winter months or in the colder months. Deer mice have a natural habitat in that area, and they got in between the walls and started nesting. When they excreted, it became aerolized, and so the guests of those tent cabins were exposed to the hantavirus. That's what it's called. So it led to injuries. There were some deaths and some personal injuries. And we handled several of those cases in the Northern District of California under multi-district litigation. So that's one. Another interesting case is a set of cases also in California called valley fever. Valley fever is another airborne fungus that causes injuries. And these cases are endemic to an area in California. Many prisoners, federal prisoners, sued the United States saying that they were exposed to valley fever, and the United States, the Bureau of Prisons and its contractors were negligent in the way they housed them, in the way they notified them of the type of area they were in. And so they sued the United States. So that's a little different. One case that we're involved in, I won't talk about the details of it, but PFAS, firefighting foam. We're currently involved in those cases. That is a foam that was most effective at putting out oil fires. This foam was used primarily to put out fires, say, for helicopters during a war. And later, it was determined that there may have been some aspects of that foam that caused contamination. So we're defending those cases now. Let me give you one more. So Go King Mine is another case that we're currently involved in. And you might recall that in 2015, EPA and its inspectors were inspecting a mine near Colorado. And during that inspection, the mine gave way and 3 million gallons of mustard-colored water flowed over more than 3 states. I remember the pictures on the news where I just saw a mustard-colored water flowing over 3 states. So we're involved in those cases as well. So that's a snapshot of cases that are different from our World War II cases.
Bridget, the breadth of your work is truly fascinating. In just a few minutes, you've explained cases you work on that relate to mold, to viruses, to firefighting foam with PFAS, and with mining waste. So thank you for so clearly explaining those complex matters. Now, if I understand correctly, if DOJ believes that the United States is clearly liable in a given case, perhaps, for example, one of the cases you described, the policy of your office is to admit liability and to pay a settlement. Is there an example that you can provide or have already provided?
Sure, I can give an example. So the way it works, Kathryn, is we protect the public fisc, right? But we're the United States. We defend the United States. So we try to do what's right. And if we get a case and it's a clear case of liability, under the Federal Tort Claims Act, state law controls the law of the case, right? And so if we look at the state law that we're in, and there are no defenses, and there are no federal defenses under the statute, my office goes to the front office of the Department of Justice, and we get permission to admit liability. So we can't just arbitrarily do it. We have to get permission. It has to be signed off at a few levels. And once we get permission to admit liability, we will typically try the case on damages, though. We'll try to litigate the case to bring the damages down, because it's been our experience that a lot of times when the plaintiffs file their administrative claim, which is the prerequisite for filing an FTCA case in court, the damages are bloated. And so we're protecting the public fisc, the taxpayer money. So we try to litigate the damages and bring those down some. A lot of times that leads to a settlement. For example, a few years back, we were involved in a case in Idaho. And it was a case where a Department of Agriculture control device was accidentally triggered and it released some cyanide. And the cyanide injured a plaintiff, maybe a couple of plaintiffs. And that's a case where we got permission to admit liability. And then we tried the case on damages, not tried it. We litigated it on damages because it never got to trial. We were able to resolve the case for a reasonable amount and adequately compensated the plaintiffs in those cases. So that's the process. First we try to reduce the damages. And if we can, then we'll try to settle it. But we don't automatically settle the case after we admit liability.
That all makes a lot of sense. Do some of these cases involve the application of novel theories of environmental law? And maybe you could give us an example of such novel theories and where they might be under consideration in other areas of environmental law.
Some of the novel areas would be cases that we defend along with another office called Environmental Natural Resources Division, ENRD. So ENRD does affirmative work and defense work. And they usually defend cases that are filed under an environmental statute. When we work with them, we usually get counts based on negligence as well. So based on injuries and negligence. So when there's a complaint that's based on an environmental statute and injuries and negligence, our two offices work together. And so ENRD handles the CERCLA component of it, and my office handles the tort component of it. So that's typically the way it works. And a novel issue or novel defense that we use sometimes that comes to mind is something called 113H. It's a part of the CERCLA statute that says that if an area is under removal or remediation, you can't sue for conduct at that area. So a lot of times when we work with ENRD, those cases are under a CERCLA statute. They're ongoing remediation matters or ongoing removal matters. So we'll file a motion to dismiss saying that under 113H, we can't be liable, we should be dismissed. So I hope that answered your question. Those are some of the novel, interesting aspects of our case. We also work with constitutional torts quite a bit on the mode cases. And here's how. Most of those mode cases, the recent mode cases, are filed by persons who are incarcerated, most of them, not all of them. And so typically they'll also add a count that the prison guard violated the plaintiff's constitutional rights by allowing mold to grow. And so what we'll do is we'll handle the mold aspect of the case, and then constitutional torts will handle the constitutional aspect of the case. So did that answer your question, Kathryn?
It did. It did answer my question. It's a bit like an issue spotter from law school, given all the different theories of law that you're working with and defending against. So looking toward the future of environmental law, does your section work with other sections on environmental policy and law? And if so, could you give us a few examples?
Yes. So again, my office exists to defend and protect taxpayer money. So we don't make policy, but we do comment on pending legislation that might impact our practice of law. So the Department of Justice has an Office of Legal Policy, and they look at all the pending bills. And if there's a bill with an environmental component of it, they'll send it to my office. We will look at it and we will get back to them and say, we want to comment on this because it could impact our cases going forward, or no, we don't have any comments. And they regularly do that, and they send it to ENRD and other offices. So many offices have the opportunity to comment on that legislation. So again, we don't make the policy, but we are engaged if it will impact our cases. Now, with law that impacts our cases, we do strategically decide whether we want to really shore up our defenses. So some of the cases that come before us are better than others in shoring up some of our cases. And when we shore up those defenses, we put a lot of time and effort into it to try to make sure that we can be successful in court so that we can use that defense down the line.
Thank you, Bridget. Cathy?
That's just fascinating, isn't it, Kathryn? Thank you so much. This is a wonderful education for us all. And Bridget, let's turn now to talking about your work with the Women's Bar Association of DC. And this year, you are our president of the Women's Bar Association of DC, which is the oldest bar association for women in the nation. Could you please share your goals and achievements for the WBA this year and how you work with other organizations on the mission of improving the role of women in the legal profession and other key WBA goals?
Sure. It is my honor to serve as president of this remarkable organization. And I mean, it is outstanding. This organization has been in existence since 1917. And since that time, it has been advocating for women's proper place in the legal profession. Our mission is to maintain the honor and integrity of the profession, promote the administration of justice, advance and protect interests of women, and promote their mutual improvement, and encourage the spirit of friendship. And I always emphasize that last component, the spirit of friendship, because let me just share something with you. I just had surgery on February 2nd. And since that time, the expression of sisterhood and friendship has been undeniable. I can't tell you how many homemade dishes were delivered to my home so that we didn't have to worry about meals, breakfast, lunch, and dinner, how many flower bouquets we received, and text messages and calls and cards. It's a true spirit of friendship. And when I recruit co-chairs for the organization, I always tell them, this organization is second to none because you feel a love and a community that you don't always feel in all organizations. So I just wanted to put that plug out for the Women's Bar Association first. My theme this year was getting back to the basics. And that's because I looked around after we had been quarantined or locked up, so to speak, for a year after the COVID-19 pandemic. And I knew that we had to prepare our members to go back to the regular practice of law. We had to get back to the basics with substantive matters, with social cues, like, do you shake a hand now? What do you do? It was things like that, and many of our struggles remain the same. And so we are getting back to the basics, and we're working with other organizations. We work with the Washington Bar Association. Just yesterday, we had a program with the Asian Pacific Association. We have programs with GWAC. We work with Women Lawyers on Guard. We believe we're stronger when we're in a coalition. And so we work together on important issues.
That's brilliant. And I just want to share that it is continuing to be a remarkable year under your leadership, Bridget. And the fact that the organization has only gotten stronger during the COVID pandemic is truly a tribute to all that you and the organization has been doing. Your leadership is truly outstanding. So let me just make that plug for you.
Oh, thank you, Kathy. That's very kind.
And one question that we all have, I'm sure, on our minds is how do you juggle your Department of Justice leadership and management responsibilities with your leadership of the WBA?
Mhm. So before I tell you about juggling, let me just tell you a few of the main things that the WBA does or has done this year. We have endorsed executive branch and judicial candidates. We have a wonderful career toolkit. I'll just tell you to go to our website and see it. We have over 600 items on there to help people with their professional development. Soon to be over 1,000 items will be on there. We have a career development program. We have a strong mentor program. We issue statements on social justice. We engage in social media, and we emphasize wellness and health, especially coming out of this pandemic. Juggling. Well, it takes organization. It takes prioritizing, and it takes balance. And I always say I work an 18/7 day. So I work 18 hours a day, 7 days a week, just because it's hard to get it all in. But what I do is take the thing with the most immediate deadline first, and I try to get that done and move on to the next. So it is a balancing act, but that's the best way to get it done. I, try to get organized and make sure you respond to everything, but in due time.
Well, you do it brilliantly, Bridget, and we're all happy to hear these very helpful tips. Also, on a very practical level, how do you de-stress and where do you look for support when we all need it?
I take many deep breaths during the day. Sometimes when I realize that I'm supposed to be on a Zoom call and it's 2 hours before and I haven't looked at the documents, I just take a big breath and then I prepare. So that's one thing. I believe in spa treatments. So sometimes I have to step away and take care of me. And that's important to me. I schedule that like I schedule everything else. I'm a very spiritual person. So I pray a lot. I pray, all the time, and ask for guidance and support. And I have a supportive husband who allows me to work on WBA and do all my other work. And, he can tell when I'm stressed out and he'll say, you know what? I don't care when that brief is due, Bridget. We're going out to dinner tonight. So that always helps me. So, it takes a village. We have a wonderful organization with WBA. And if it gets to a point where it looks like I'm pressed and I can't get something done, I'll reach out to one of my WBA community members and say, hey, can you take this? And it's taken care of.
Thank you for sharing that with us, Bridget. I feel inspired just listening to you. So let me ask you a question. It's clear from what you shared with us that you're very passionate about working with others in many different ways. How has your career path led you to your current roles and position?
Well, you're right. I'm very passionate about helping people reach their goals. I think that's my hobby, honestly, because I feel like I do that all the time. I can't say that I planned this career path. I think, honestly, when I started practicing law in Knoxville, Tennessee at Lewis, King, Krieg, and Waldrop, that's the name that it was then, at that law firm, I thought that I would be there. I'd be a partner there for many years, and eventually I'd go to the bench. So that's what I thought I would do. Shortly after I made partner, maybe, I don't know how long it was, but a year or two after I made partner, my husband got transferred to Washington, D.C. So I came here, and I was good friends and on boards with Senator Lamar Alexander's chief of staff. So I started working in that office. And then I missed litigation. Litigation is one of those things where you love it or you hate it. And it gives me adrenaline and it keeps me excited. And so I missed litigation and I went to the Department of Justice. And I ended up practicing in the same area that I practiced in private practice. The difference is in private practice, my client was a big corporation or an insurance company. When I came to the Department of Justice, my client was the United States or a federal agency or a federal employee, but the concept was still the same. So I ended up on some very big cases when I first came to the department, and I ended up staying. So it was a strange way to get to environmental torts. I went to environmental torts in 2013. Prior to that, I really didn't practice law in environmental torts. I was a litigator, but that's another thing. I feel that if you're a litigator, and you can pollinate your skill set in different areas of the law. And so I can't say that this was a planned trajectory, but it's been a good one.
Bridget, these are truly impressive achievements. Can you share with our listeners some challenges that you may have had along the way in being a private sector partner and working at a very senior level at the Department of Justice and in your work with the Senator?
When I first started practicing, again, I was in Knoxville, Tennessee, and it was challenging because I and one of my colleagues were two of the first African-American lawyers to go to big law firms. I think were two more prior to us that we were aware of, but we were both hired by big law firms out of law school, but we didn't have any assistants. We didn't have mentors. We relied on one another. And so in addition, my firm was in Knoxville, so our client base was East Tennessee. So all of my cases were all over East Tennessee. My clients were all over East Tennessee. So I practiced in some areas where people had never seen a Black person. So it was challenging in that I had to always prove myself and show that I was worthy. There were times I'd walk into a courtroom and the clerk would say, "Here's your plug-in, Bridget," because they thought I was the court reporter. And I would say, "No, I'm the lawyer." I didn't take it personally. I just, explained to them, I'm going to ask the questions today rather than type the questions. So those things were kind of challenging, but they're building blocks, And so I learned things through that process that have helped me throughout my career. And it has made me remember what it's like to start out as a young lawyer without any help. And I am always available to people to serve as a mentor because of that experience. I don't want anyone to ever have to struggle the way that I did to try to figure out how to make it, because you make a lot of mistakes and you never forget those mistakes. So they always help you. But if I can do something to smooth the path for someone coming after me, I always do that, no matter how busy I am.
Bridget, those are very welcome words. And I think we can all benefit from your thoughts on how to address some of these difficult situations with humor and with grace and with diligence. Truly inspirational.
If I can just interject on a personal level, I have to thank Bridget. I have personal knowledge about her assisting with a young friend of mine who had just graduated from undergraduate school and was contemplating going to law school and perhaps working as a contractor for the U.S. Department of Justice. And he was so concerned. And Bridget took the time to speak with him, and it was so very much appreciated. So it's wonderful that this sort of thing, Bridget, makes such a difference in people's lives, right, Kathryn?
It does, especially the mentoring mantra. I think it's something we can all learn from and implement.
We certainly follow that at the Women's Bar Association, and I tell young lawyers all the time, this is the place you want to be because we have some of the stars of the bar in our organization, and they'll make themselves available to you. Why struggle to figure it out when you can have someone to at least give you a roadmap? You may not follow it, but it's a template that you may want to use.
Couldn't agree more. Are there any other lessons that you would like to share to help mentor others in their career paths?
One thing I always tell people, I believe in the 5 Ps. Proper preparation prevents poor performance. If you are prepared, you will be successful. I remember walking into courtrooms where I'm litigating against someone with 20 years of experience and I'm 2 years out, but I knew the file inside out and I knew the law inside out and I had the confidence. So that's my uniform, preparation. I also try to encourage people, be reliable, be dependable, follow up, respect everyone, not because you may need them later, but because everyone deserves your respect. Even if they are not a lawyer, even if they don't have a degree, treat everyone with respect. It will bode you well. Complete every task. If you cannot get it done within the deadline, let the person know that you're behind and you'll get to it, and be responsive. Those are my suggestions for success. And they transfer from the law to bar associations to personal experiences.
That's so excellent. Wonderful tips for life. And we so appreciate hearing this wonderful information. Truly, Bridget, we want to thank you so much for taking the time to share your very impactful career with us and your outstanding achievements as well. You truly are making a difference in people's lives and in environmental law. And we so appreciated learning how you have succeeded and also helped and continue to help others succeed. We want to thank you, the DC Bar, the WBA, and our listeners. And we invite you all to watch for our next Making a Difference podcast. Thank you so very much.
Thank you for having me.